Good afternoon. This is Ann Waldo, Senior Counsel at Genetic Alliance. I am delighted to bring you this webinar today explaining how and why genes are patentable. This session will be an introduction to gene patenting law. Now, as many of you know, Genetic Alliance recently filed an amicus curiae, or friend of the court, brief in the gene patent case, Association of Molecular Pathologists versus the United States Patent and Trademark Office and Myriad Genetics. Summary judgment was just rendered for the plaintiffs on Monday, and a copy of our amicus brief is available on our website. Since Genetic Alliance often gets asked why we filed that brief, I wanted to add just a word about that. We filed that brief not because we wanted to take a stand with any of the parties in the case, and not because we're supportive of the exact scope of any particular claims of the patents at issue in the case, but rather because we are troubled by, and we therefore oppose, the remedies that the plaintiffs were asking for, which was a wholesale diminution of legal intellectual property protections for isolated and purified human genes. So without going into that, our whole position and rationale, I just wanted to mention that we think that fundamental scientific discoveries, as important as they are not enough. We need an economic and legal system, including intellectual property protections, that protects and incentivizes translation of basic scientific discoveries into tests and treatments that actually become available to patients. Now, personally, as I started getting familiar with this area of law a few months ago, the whole area of gene patents, I found it quite confusing. I'm also convinced that you cannot, and it's unwise to try, to learn patent law from press reports or from pleadings in a lawsuit. Therefore, to sort this out, I turned to John Conley, a law professor of mine at the University of North Carolina who has a special focus on genetics and biotech. I really think you need to understand something and get the facts right, answer your threshold questions about what the law actually is, before you can form a reasonable opinion about whether the law is good or bad, or how it should be changed, if at all. In other words, I wanted us to have some light before we have heat. That's really consistent with Genetic Alliance's mission overall, which is to educate, collaborate, help all the society's players in the healthcare space move forward in rational and in a wise manner. Now, as for the heat side of things, please stay tuned, for we plan to have another webinar soon where we will assume that you guys have all absorbed the basics of gene patent law, and we can move on to the controversies and disagreements that are so prominent today, as evidenced by the recent Myriad decision. Without further ado, it is my pleasure to introduce John Conley. Not only is he a law professor focusing on intellectual property, genetics, biotech, and scientific evidence, but he is also an anthropologist. So he tends to approach controversial questions like this with a real curiosity about human beings. I think it will be a treat for all of us to have him teach us today about gene patent law. John?
Okay, thank you, Ann, and hello, everybody. Let me say a couple of things preliminarily. First, I am assuming an audience primarily of non-lawyers and in particular of non-patent lawyers. So we will take the law slowly and step by step. Second thing is about Myriad. That's what's in the news. That's what everyone is talking about. I think if you're really going to understand what Myriad means, and as importantly what it probably doesn't mean, you need to do that in context. You have to see where the issue has come from. So I am going to take it step by step, and Myriad will come last. We'll address that at the end, having established some context. So here we go. And let's go to square one, slide one, square one, and that's the question of what's a patent. People usually think of a patent as a monopoly. It's more accurately thought of as a bundle of rights to exclude, a bundle of rights to prohibit other people from doing things. And in particular, it's a bundle of rights to prohibit other people from making, using, or selling your invention for 20 years. And that 20-year clock runs from the date you file the application. And some of you may be in the pharmaceutical industry, and you're aware that people who hold drug patents have some opportunity to recapture some of the time that gets eaten up in FDA approval, but it's 20 years. Important thing about patent infringement is that if someone makes, uses, or sells your invention without authorization, their intent is irrelevant. You can be innocent and be a patent infringer as long as you do it. Another significant legal point comes up in the Myriad case is that Congress's authority to grant patents is right in the original draft of the Constitution, so it is ancient. It also means it's a matter of federal law. There aren't any state patents or patent laws. The Constitution sets out an economic bargain rationale. This is not a natural law kind of thing like you might see in Europe, but it's clearly an economic bargain. To promote the progress of science and the useful arts, language of the Constitution, Congress is authorized to grant, for limited times, exclusive rights to authors and, importantly today, inventors. And the government is trading this quasi-monopoly for disclosure. To get a patent, as we'll see, you have to disclose a lot. And the purpose of this is to encourage the exploitation of inventions so that we don't have people locked in their garages sitting there on their inventions, but they're getting out there, investing in them, and exploiting them for public benefit. Okay, what can be patented? Again, the Myriad case. New, useful, and non-obvious inventions. New is a very technical term. So is non-obvious. Useful means what it means, useful. Myriad is about patentable subject matter. This is the first requirement that the Patent Office and a court imposes in looking at a patent. Is it the kind of thing that the patent law and the Constitution allow to be invented? And the categories enumerated in the Patent Act are machines, manufactures, tangible things that people make, compositions of matter, that's where genes are going to go, and processes. So things, products, the first three categories, and then processes or methods. And also patents are available for improvements on existing kinds of patentable subject matter. There are some things you can't patent, and these are a set of forbidden categories that go way, way back in the case law. You can't patent abstract ideas. You've got to do something with your idea. You can't patent a law of nature. The courts often give the example of the law of gravity. That includes pure mathematical algorithms, which, as you can imagine, is important in all kinds of areas, including computer software. And you can't patent products of nature. We'll explore what that means. And the reason you can't is because they're not inventions, which the Constitution and the Patent Act describe as the protectable category. Let's dispense with utility first. New, useful, non-obvious inventions. Utility is usually a no-brainer. If anyone's got a beneficial use for it, that's it. Historically, there have been only two categories of hard cases, what are called chemical intermediates, chemicals that are like useful chemicals, but we don't know yet what they do, and genes. How much do you have to know about a gene you're patenting before it meets this utility standard? Well, you probably have to know what protein it codes for, what protein it makes, and you probably have to know something about what that protein does. And the Patent Office spent a long time working on its utility guidelines for the patent examiners, and it came up with something that to me is meaningless. You must show a specific, substantial, and credible utility. Okay, but not usually a problem. Non-obviousness can be a huge problem. You can't patent something that is merely an obvious advance over this thing called the prior art. The prior art is the sum of public knowledge in a field. So if we're talking about genetics, a gene patent, the prior art is all the public knowledge that's out there. When the Patent Office and courts apply the non-obviousness standard, they do it in a necessarily subjective way. And here's what they do. This is the second bullet point. They construct this hypothetical person, a person of ordinary skill in the art. That's a person who's generally knowledgeable about the field. And then they ask this hypothetical person, look at this invention, look at it as of the date it was invented. would you have thought it a merely obvious advance over everything in the prior art? So a court or the patent office stands in the shoes as of the date of invention of this person of ordinary skill in the art and poses this question. As we'll see, the Supreme Court has just made it a little easier to knock out patents on obviousness grounds. Okay, what about the patent process? The patent process, as I said, is a bargain. You trade information for this quasi-monopoly. And the information has to meet a particular standard. You have to give what's called an enabling written description. In other words, in your patent application, and ultimately in your patent, you have to say enough about your invention so that somebody else, not coincidentally our old friend, the person of ordinary skill in the art, somebody else with ordinary knowledge of this field could build your invention, could use your invention. Now, of course, they can't, because that would be infringement, but you give them the information that would enable them to do so. So the level of description that's required is very high. You get a lot, you get a near monopoly, but you pay a lot, a huge level of disclosure. We're going to look at some claims. They are the core of a patent. They define exactly what's patented, and they define exactly what infringes. Infringement is defined as doing just what's stated in the claims. And we'll look at some claims in a moment. So they're the business end of the patent, the operational part of the patent. Interesting aspect to the U.S. patent system, which distinguishes us in ways that most of the world doesn't like from the rest of the world, and that is the validity of the patent can be challenged in litigation. So if I sue you for infringement, your defense can have two components. You can first of all say, I didn't do it. I'm not infringing. What I'm doing is different from what's in your claims. But you can also say that my patent was wrongfully issued. And you can win the case by going back, having the court go all the way through this novelty, utility, non-obviousness, patentable subject matter analysis, and proving to the court that the patent office was wrong. So you can get the patent invalidated in litigation. This is part of what I always think of as the back-end loading of the U.S. patent system. Our patent system is designed to err on the side of granting patents. Close calls go to the applicant in our system. We underfund the patent office. We don't have enough examiners. We know that. We rely on the market and the courts to screen out the bad patents. Now, a lot of reasonable minds differ on this, but that's the way we do it in this country, unlike in most of the rest of the world. Okay, what about DNA technology, which is what we're going to go to specifically? What kinds of patents are granted? What kind of subject matter is covered in this area? Genetically engineered organisms, organisms whose DNA has been changed. They are routinely patented. At least until a couple of days ago, isolated and or purified genes, we'll talk about what those words mean, isolated and or purified genes have been routinely patented for more than 20 years. Gene-related products and applications, diagnostic methods that depend on genes, and therapeutic methods that depend on genes have also been routinely patented. And so have proteins and cell lines. We'll look at a couple of those patents. We have only one Supreme Court genetics case, and it's now 30 years old, which is astonishing when I think about it. The Chakrabarty case. Diamond was the patent commissioner. Chakrabarty got a patent on a bacterium, a species of Pseudomonas, that had new DNA inserted. In particular, it had plasmids, rings of DNA, inserted into the bacterial cell in a combination that was not thought to occur in nature. And with the plasmids that Chakrabarty inserted, this species had enhanced oil-eating properties. You dump it on oil spills. And with all these plasmids in a single cell, the genetically engineered species was much more efficient at eating up oil spills than the prior technology, which involved one species at a time and they inhibited each other. Okay. Before the Supreme Court in Chakrabarty was the question of whether this is patentable subject matter. Is this a composition of matter that can be patented? And the big issue back in Chakrabarty was whether you could patent something that was alive. Was that a barrier to patentability? The Supreme Court held, yes, it is patentable subject matter, and the fact that the invention is alive is not a barrier to patentability. The court said there's nothing in the statute, there's nothing in the Constitution which excludes living organisms from patentability. If you want to take up that fight, go to Congress and get them to fix it. Well, if you've been holding your breath since 1980, you are very blue by this point, and Congress has taken no action in response to Chakrabarty. A couple of interesting things about Chakrabarty. One is it was really close. It was 5-4. Could readily have gone the other way, and the history of applied science would have been quite different if it had. The other, and that's going to be important in considering Myriad, is that the court said that there's a fundamental distinction between products of nature, which are unpatentable, and human-made inventions, which are patentable subject matter. This one was on the inventive side of the line. In a way, it's regrettable that this was the case where they laid that out, because this was an easy case, in the sense that Chakrabarty created a whole species not thought to occur in nature. So this was well to the inventive side of the product of nature line. So aside from the rhetoric of the case, the holding and the facts are not very helpful in deciding hard cases, but that's all we got from the Supreme Court. Okay, what about patenting genes themselves? This case, Amgen, at least until the Federal Circuit decides Myriad, is the single most important gene patent case, even though it's now 19 years old. The Federal Circuit is a branch of the United States Court of Appeals. It sits in Washington, D.C., lovely building on the, I guess, the northeast corner of Lafayette Square. And they are a national court, and they hear all patent cases. So they are the patent court. The vast majority of patent cases end there. The Supreme Court, from time to time, takes a patent case. They don't have to take them. Sometimes they do, rarely. So the Federal Circuit is extremely important. Here's the claim, the critical claim in Amgen. A purified and isolated DNA sequence consisting essentially of a DNA sequence encoding human EPO, a human protein essential to the blood carrying oxygen. It is the protein that plays a central role in the Tour de France every year. Okay, so the claim, as I said, is the business end of the patent. It's what you get. And look at how this is drafted. A purified and isolated DNA sequence. Well, what DNA sequence? One that is more or less the DNA sequence that codes for this protein. So this is really breathtaking. You work back from the protein. Whatever DNA sequence is essentially the DNA sequence that codes for this, any such DNA sequence is monopolized by this patent. Can't make, use, or sell it without Amgen's permission. And by the way, let me throw in a point here. We do not have a meaningful research exception in this country. We have a custom-tailored exception for people working on generic drugs, but that's it. We don't have any kind of a general research exception. So this would bar research, because that's using. Okay. Now, it was taken for granted in the Patent Office and in the Federal Circuit that this claim covers not a product of nature, but a human-made invention. Why? Critical question. Okay. This slide diagrams the law's original understanding of why genes are patented. Now, scientists in the audience may find this primitive, out of date, simplistic, offensive, but this is the law's original understanding, going back more than 20 years, of why genes are patentable, and this understanding still informs patent practice. Okay, on the top line, we've got DNA, as it would naturally occur in a cell. So what happens to DNA when it's going to make a protein? Here's the law's understanding, as embodied in the patent office practice and in the case law. DNA, in this view, consists essentially of two kinds of DNA. The so-called exons or coding regions, which are blue, and the so-called introns or non-coding regions, which are orange in this diagram. The specific task of building a protein is laid out by the coding regions. In the body, DNA is transcribed or written down by RNA, its somewhat impoverished cousin that lives in a trailer park. The RNA copies everything down. This is the A's and T's and C's and G's, and it does this using a complementary principle. An A in DNA is encoded by a U in RNA, a G by a C, and so on. And the way it's rendered here, the blue, the coding regions, are the green in this RNA transcript. This is how the information is going to get out of the nucleus of the cell and code for a protein. The orange regions, the non-coding regions, are also represented as orange in this RNA transcript. Now, this is a primary RNA transcript. This is the first thing that happens. But before the RNA carries this information out of the nucleus of the cell to make a protein, it goes through what's called splicing. Now, biology is striking to me for its linguistic perversity, and so the introns, you'd think they were going to stay in, right? No, they get cut out. The exons, X is the Latin preposition meaning out, the exons, they stay in, but that's just a side issue that irritates me. So you have the coding regions only in this mature RNA transcript. This transcript gets carried outside the body, I'm sorry, not outside the body, outside of the nucleus of the cell, and is then used by other chemicals outside of the nucleus of the cell in order to build a protein. That's what DNA does. That's its core function, building proteins. Okay, focus on that green, mature RNA transcript at the bottom. In early DNA work, this still happens, but there's a lot more going on, scientists built a kind of synthetic DNA called cDNA on that transcript. You see that you go from DNA to RNA, you do the splicing, you get down only to the coding, the protein-building regions, and you get this RNA transcript. Well, you can go backwards. You can reverse this, and you can make DNA that captures all the information that's on that RNA. And this DNA, called cDNA, was the early basis of genetic technology and was what was claimed in the very earliest DNA patents. Okay, why would cDNA, that would be a complementary copy of this RNA, not be a product of nature? Well, because it's chemically different from anything you see on the screen, which does occur naturally in the body. Is it like the RNA in the bottom? No. Why not? Well, because it's DNA, which is a different chemical. Is it like the primary RNA transcript you see in the middle? No, because it's DNA. Again, well, is it like that DNA up at the top? No. Why not? Well, all the orange stuff is thrown out. It's a piece of DNA that has only the blue, that has only the coding regions left. So patent law looked at this and said, we have a chemical that is significantly different from any of the related chemicals that occur in the body. Therefore, that's patentable subject matter. So this was the key to gene patents surviving product of nature scrutiny back in the day. Not exactly the same. Now, we should add, again important in Myriad, that the information contained when we look at the protein building function is exactly the same information as in the three chemicals you see on the screen. But the structure is different. And patent lawyers early on sold the argument that these are just chemical patents. Structure's all that counts. Information carrying capacity of DNA is irrelevant. So that's how this all began. Okay, let's go back to this Amgen claim. Against that background, it doesn't say just genes, it modifies them with two adjectives, isolated. And if you read the Amgen patent, they define isolated as outside the body. In this patent, they also define purified as meaning non-coding regions. So for the reasons I just went through, a patent like this was viewed not as claiming a product of nature, but as claiming a chemical that in its structural form was not found in nature. cDNA, I talked about it. And again, structure, function, information. Function information, not considered. Chemical structure was. Now, bottom line here, very important, is the gene in Amgen that is patented. Not in this claim, the process for making it, not products and applications. Those are all possible, but the power of a patent like this that it is the gene. You want to test it, you want to do research on it, you want to use it diagnostically, therapeutically, you run afoul of a patent like this. Okay, here's the Skolnick patent. This is the Myriad patent. This is the broadest of the Myriad patents. An isolated DNA coding for a BRCA1 polypeptide, that is for, this is the breast cancer susceptibility gene, said polypeptide or protein having a specified amino acid sequence. Proteins are chains of amino acids. So look how this one works. The gene that codes for the protein that has an amino acid sequence that we're going to show you. So we work back from protein to its amino acid constituents, and then we ask what DNA codes for those amino acids. That's what we claim. Footnote here, there is a property in genetics called degeneracy. Again, linguistic perversity. It really means redundancy. And more than one DNA sequence will code for a given amino acid. So this is even broader than it looks. Let's look for the modifiers that might limit it. I see isolated, but I don't see purified. So here's a patent that goes through, and the only limit on the claim on the gene is that it be isolated. This can have this gene, the gene covered by this patent, can still have the non-coding regions in there. So this is an even broader claim than the Amgen claim. And isolated, if you read the patent, means isolated, outside of the body. So this gene, outside of its normal chemical setting, context in the body, is covered by this Myriad patent. We've got a question you want to go to?
Actually, this is a question of my own, so forgive me if it's too ignorant, but didn't the 2001 Patent Office guidelines establish that they would be granting patents, or patents would be considered to have utility if the gene sequence was isolated and purified? And if so, does that mean that this language in this claim might not have been granted subsequent to the 2001 guidelines?
I don't think so. I mean, I guess I don't think so, since I don't agree with that proposition. I think utility is easy here. That was, I think, what you're saying was a way one could show utility, but this Skolnick patent has utility covered. You know what the sequence is. You claim the sequence, you know what protein it codes for, you know what the protein does.
So you don't think it's necessary that it be both isolated and purified?
No. Well, the Patent Office hasn't been of that view for a long time.
Okay.
No, I don't think that's an issue. Just an example of a protein patent, this Turley receptor protein patent that I picked out among huge number, an isolated protein comprising the amino acid sequence of figure 2. So this patent claims a protein in isolation from the body that has a specified amino acid sequence. Again, to me, breathtaking. This is WARF, the Wisconsin Alumni Research Foundation. This is a patent on a line of stem cells. Stem cells was very much in the news, very controversial in some respects, at least in the last administration. These are these cells that can become anything over the course of the life of the organism. They're basic cells that are not yet differentiated. Look at this one. A purified preparation of primate embryonic stem cells, which is capable of proliferation in vitro, in a test tube, maintains a karyotype, in other words, is stable, maintains the potential to differentiate, in other words, is a stem cell, can become so-called pluripotent, can become different kinds of cells in the organism, and will last on this particular medium. What this is a very basic definition of a cell line for any kind of primate, that's just not us, that's monkeys and lemurs and everything, of any kind of primate stem cell. This one is enormously broad. So if you want to set up a primate cell line, and all this 1 through 4 stuff is the definition of a cell line, you want to set up a primate cell line, you have to have a license from the University of Wisconsin. Good for Bucky Badger, expensive for the rest of us perhaps. They were re-examined, these patents. They reportedly were being revoked for obviousness, but didn't happen. In the spring of 2008, they were reaffirmed. So this one doesn't get as much publicity as Myriad, but this is another example of how far we've gone in allowing patents. Okay, let's look at some cases. Supreme Court almost got back in the biotech game in 2006. In the LabCorp versus Metabolite case, the invention here was a process for diagnosing vitamin deficiencies. And the claim here covers any test that measures the level of homocysteine in the body, and then you look at it, and you see whether the level is elevated above the norm, and you use some very basic knowledge to decide whether that level is indicative of a vitamin deficiency. So you take fluids out of the body, you do this very simple measure, and then you can go to a table and say, well, what does that measure show me? This actually worked its way through the courts on other issues other than patentable subject matter. The Supreme Court took the case and out of the blue told the parties to file briefs on whether this invention violates the prohibition on products and laws of nature. Was this a patent on a simple law of nature, the relationship between this protein and vitamin deficiency? And particularly, the Supreme Court said, might the patent claim a monopoly over a basic scientific relationship? The court was concerned, could a doctor infringe through doing routine tests and calculations? Could a doctor infringe in his or her head? Then, equally out of the blue, the Supreme Court said, no, we didn't mean it. Forget it. We kicked the case out. We dismiss our consideration of the case. Justices Breyer, Stevens, and Souter filed a very strong dissent, indicating that they really wanted, 3 of them really wanted to look at a case like this. So, well, we don't know what Sotomayor thinks, having replaced Souter, but at that point it looked like we had 3 votes for putting some brakes on biotech patents. And here's what Justice Breyer said. At most, the patentees had simply described the natural law at issue in the abstract language of a process. So that got everybody's attention, but then it went away. Here's a utility case, Federal Circuit, 2005, express sequence tags. These are short cDNA sequences. And when you have one of these sequences, you know that it's part of a gene. So you can use one of these express sequence tags. It's coding stuff, coding DNA. And you can fish for genes in DNA libraries, which don't have books in them. They're GUI libraries. You can use these ESTs as fish hooks. When they find a gene in a DNA library, they will link up with it. They will hybridize with it. And then you reel it in. And you say, I've caught a gene. Problem, when you have them, you don't know what gene they came from. And you don't, beyond that, you don't know what the gene they came from does in most cases. So the claim on utility here was they're really useful in research in the ways I just described. But the Federal Circuit said no. This was a rare case where utility is problematic. You don't know what gene this little fragment comes from. You just know that it comes from a gene. And moreover, you don't know whatever that gene is, what it does. That's not enough. So ESTs thrown out on utility grounds. That's rare. This one is very interesting. Apotex had a generic drug compound on something called PHC anhydrate. That was the subject of an earlier expired patent. Did their generic drug infringe SmithKline's patent on something called PHC hemihydrate? Two kinds of PHC. Anhydrate in the public domain, hemihydrate patented. Interesting thing here was that anhydrite tablets convert naturally into hemihydrate, including in your body. So you take the generic drug, your body turns it into the patented drug. You are a walking, talking patent infringement. Maybe. Are you making the patented compound? No, they're not going to sue you, but they are going to sue Apotex for contributory infringement, for contributing to this infringement that's going on in your stomach. Mercifully, the Federal Circuit threw out this patent under an obscure doctrine called inherently anticipated, and I don't want to talk about that, but here's what I do want to talk about. One of the judges on the Federal Circuit, Judge Gaharsa, he said the claim encompassed unpatentable subject matter, and the reason is that SmithKline claimed all crystallized PHC, including the ones that result from a natural physical process. And they claimed a synthetic compound created by humans in a laboratory, never before existing in nature, that is nevertheless capable of reproducing itself through a natural process. And because this invention covered both, this claim covered both the non-natural and the found in nature categories, it's not patentable. So here's another judge taking very seriously this product of nature problem. But he said, well, no big deal. You just could have written the claim to limit yourself to the synthetic kind. So it's an interesting case and another example. Obviousness. I said the Supreme Court has given it more bite. A case having nothing to do with biotechnology, a case having to do with automobile brake pedals, KSR International, 2007. You don't have to pay attention to the specifics of this case. The lesson for us is that in looking at the prior art and deciding whether a particular invention would be obvious, a court and the patent office can look not just at the prior art, but at the inferences and the creative steps that this person of ordinary skill in the art would employ. You can look at whether it would be obvious to try to make the invention. It sounds very technical, but it makes it a whole lot easier to show obviousness and therefore defeat a patent. The Federal Circuit applied it immediately to biotechnology. These were patents on the collection, preservation, and use of stem cells. Not on stem cells themselves, but these processes. And Federal Circuit applied this KSR case. It was reasonable for the inventors to infer things. So even though the invention itself wasn't in the prior art, even though it was not literally obvious from the prior art, if you put that together, put all these pieces together, it was reasonable to try to make this invention. And therefore, this gets thrown out. Okay, next step, hugely important, in re Cuban. And the Cuban patent claimed polynucleotides, strings of DNA, that encode these natural killer cell activation proteins, important potentially in the treatment of infections and of cancer. The patent, BPAI is an appeal board within the Patent Office. The Federal Circuit affirmed the rejection of this patent on obviousness grounds. The Federal Circuit says this invention was obvious. Why? Because even though the particular invention itself was not obvious, it would have been obvious to try to isolate these sequences, because a lot was known about the proteins, and DNA sequencing methods are very widely known. This is actually a huge decision that may end up invalidating a lot of biotech patents. You put together knowledge of sequencing techniques and knowledge about the proteins you're interested in, and some patents may fall. There had been an older case, Dual, in 1995, that had rejected this obvious to try objection to a very similar gene patent. Said the fact that we know about the proteins, the fact that we know how to do sequencing, didn't make an invention obvious. The Federal Circuit says that outlook was discredited by this Supreme Court case. And biotechnology is not exceptional. We're going to apply the same rules there that the Supreme Court applied to a brake pedal. If there was a reasonable expectation of success, then the invention might be obvious to try and thus unpatented. Okay, getting up to myriad. One more. More trouble for gene patents. So we have the obviousness problem. We have the subject matter problem. This is the written description problem. We talked about how you had to enable somebody else to make the invention. Very detailed description. Ariad is the licensee of a Harvard patent on a method to treat disease by reducing the activity of a messenger protein that regulates gene expression in cells. So genes do good things, genes do bad things, especially in cancer cells. So this is a method of treating disease by reducing the activity of this messenger protein that controls what genes do and when and how much they do it. Ariad, on behalf of Harvard, got a $65 million infringement verdict against 2 Eli Lilly drugs. The verdict was reversed. There's not enough of a written description requirement. Now, this business about possession and enablement is kind of inside baseball. If you're not a patent lawyer, you don't need to worry about that. But if you want to think about biotech patents, you should think about this case, because all kinds of biotech patents, especially genetic patents, turn out to be really hard to describe. It's hard to say exactly what you're doing. You can do it, but it's very difficult to tell somebody else precisely how to do it. And after this case, which was reaffirmed by all the judges of the Federal Circuit last week, after this case, the message is that the courts should apply a very strict written description requirement. So this is another piece of evidence of nibbling around the edges of gene patents. In re Bielski, this was a business methods patent, had to do with commodity hedging, and it announces a test on patents like this, patents on methods of doing things. Again, this is a method for managing consumption risks of a commodity, commodities hedging, but potentially has broader application, and especially to things like methods of diagnosis and methods of treatment. The Federal Circuit, in this case, last year, announced what's called the machine or transformation test. Is the method tied to a particular machine? In other words, does it require a particular machine that's part of the patent claim to carry it out? Alternatively, you can satisfy it by saying it transforms an article into a different state or thing. So it brings about a physical transformation. And this particular claim fails. This case is now before the Supreme Court. Decision could come literally any day. Depending on what they say and how broadly they state their holding, Bielski could have big impact on gene-related patents in the therapeutic and diagnostic area. We have one Bielski-style biotech case. This case came shortly after Bielski, and we don't know what's going to happen to it until the Supreme Court rules in Bielski. But look at this claim. A method of optimizing therapeutic efficiency for treatment of an immune-mediated gastrointestinal disorder. The way it's described in the patent, in an example, it's a method of improving the efficiency of administering drugs for Crohn's disease, autoimmune disorder. Okay? As it's claimed here, there are two steps. You administer a drug to a patient, and then you determine the level of the drug in the patient. So you administer it, you take a blood sample, you measure its level in the patient, and then there's a table. There are threshold levels of the drug's residue or metabolites in the patient's blood. And if you see that you're below the threshold, you increase the dose. If you are above the threshold, you decrease it to avoid potential toxicity. Very simple. But in the view of the Federal Circuit, after Bielski, it's good enough. It is patentable subject matter. And they say both administering the drug and determining the level transform, cause a physical transformation. And what is that transformation? It's the transformation of the human body. Your body is different when you take the drug. It's also different after they take a blood sample. You got a little less blood. So this is, again, a kind of shockingly broad diagnostic, therapeutic patent. And depending on what the Supreme Court says in Bielski, this will stand or it won't stand. Okay, let's go to the frontal attack. This is, to my knowledge, the first time in the history of genetics that somebody has gone to court and said, whoa, those genes that have been patented in isolation are no different from products of nature. The court has not been asked to decide that specific issue until now. So the plaintiffs, the ACLU are actually the lawyers. The plaintiffs are patients, a bunch of universities, a bunch of individual researchers, and seemingly every scientific organization in the world. And what they're saying is, because of what the Patent Act says, you can't make, use, or sell, and because of the breadth of the myriad claim, the gene in isolation, we can't diagnose our patients, we can't treat them, we can't do research. That's all bad. So again, a frontal attack. The suit seeks to invalidate two breast cancer susceptibility genes, BRCA1 and 2, as well as a bunch of other patents on methods. Methods of determining whether somebody has a dangerous mutation, comparing the benign version of the gene with the gene in the patient's body. So the patents on the gene themselves and a bunch of methods. And obviously, this could affect a whole host of gene patents across the whole biotech industry and the whole biotech research world. The suit challenges the BRCA gene patents as claims on natural human genes. Remember I said it back at the beginning that the patent office and the courts and patent lawyers have all assumed that only the chemical structure counts. Well, this case says no, or the argument says no. It's the function and information that count. And the function and information of a gene in isolation are completely indistinguishable from the function and information of the gene in the body. So it's a product of nature. It violates the subject matter statute, and it also violates the patent clause of the Constitution. It's not an invention. These genes are not inventions, and their patenting does not promote the progress of science and the useful arts. So it attacks these patents under the statute and under the Constitution. They also say, I mean, it's the ACLU, so they always have to cite the First Amendment, that the screening methods preempt thought by researchers and physicians, and thus they violate the First Amendment. It's thought control. The court initially denied some motions to dismiss. That's all highly technical. The only really interesting thing there was they said that someone who didn't like a patent had standing, had the right to sue the patent office directly. That's actually pretty revolutionary. Generally, it's always been thought, if you don't like a patent, you got to go and fight with the patent holder. But this judge entertained this complaint against the patent office itself. Both sides moved for summary judgment. Summary judgment means you say to the court, Your Honor, the facts in this case aren't in dispute. The facts are clear. All you have to do is apply the law to the facts, so there's no need for a trial. So both sides filed motions along those lines. They were heard back in February. Each side was saying facts are clear, patents under the law are valid or they're invalid. Now, before 2 days ago, people were thinking, well, is there a legitimate shot here? Or is this just a publicity stunt, or more generously, an educational lawsuit? Well, who knew? The subtext here is really a policy one. Who pays for expensive tests? So that's some of the background here, and this just in. Myriad loses on March 29th. This is what everyone's talking about. The district court granted the plaintiffs, the ACLU people, granted their motions for summary judgment and denied Myriad's cross motions. So the judgment as of today is a judgment holding Myriad's patents invalid. Both the product patents on the genes themselves and the process patents on the screening methods, the diagnostics, all that stuff. The gene patents were held to violate the product of nature prohibition. This court, this judge, Judge Robert Sweet, bought the proposition that DNA is not simply a chemical, that its importance lies in its information-carrying function. That function is the same in isolation as it is in the body. Therefore, these patents are claiming products of nature indistinguishable from the naturally occurring version. The court also said that the screening and diagnostic patents were claims on abstract mental processes, not patentable subject matter. Where do we go now? Well, the case will go to the Federal Circuit. That is a decision there. Hard to see that much before the end of this year, especially since the process patents, the screening patents, are going to depend on Bielski. So people assume that the Federal Circuit will wait on that side of the case until they get Bielski. So we're going to the Federal Circuit. What will happen? Who knows? My guess today is that the gene patents probably will survive in the Federal Circuit. If I had to bet a quarter, which is all I would bet on this guess, Judge Sweet will be reversed on that. But again, depending on Bielski, there's a really good shot, I think, that the screening patents will remain invalidated. What are the practical effects? Well, I guess the message is don't hyperventilate yet, whichever side you're on here. We have one district court opinion. It's not binding on any other court right now, and we've got a ways to go before we get a decision in the Federal Circuit. We could still get an appeal to the Supreme Court, which, based on that stuff we looked at from the metabolite case, they might be interested in taking. It seems to me that this product of nature doctrine holding is more likely to stand up in the Supreme Court than it is in the Federal Circuit, given the long history of allowing these kinds of patents. Okay, I am going to, it's 1 o'clock, I will quit now and we'll turn to some questions. If you'd like to follow up by email, get more information, there's my email address here at UNC. And I work with a lawyer named Dan Vorhaus. We do this thing called Genomics Law Report. We've got a lot up there on the Myriad case and other related topics, and more to come.
Great. Thank you so much, John. And I'm going to start with the questions around Myriad, but we got some wonderful technical questions earlier as we went through the slides. So regarding Myriad, why do you think that Judge Sweet did not address the 11 cases of, quote, gene patents that have come before the Court of Appeals before? Do you think that he's thinking 2 moves ahead to Supreme Court review and just assuming that he's going to get overturned by the Federal Circuit?
Well, if I understand this right, what I think is unique about this opinion is that the ACLU asked him squarely to decide, are genes in isolation products of nature? That issue's been assumed away, dealt with in a footnote, or ignored in many other gene patent cases, but I'm not aware of a case where that was the core of the attack on a gene patent. And understandably so. When you have 2 commercial entities, as in Amgen versus Chugai, neither of those has a vested interest in sweeping aside all of gene patents. They're fighting over who gets this patent or that patent. So it really took somebody like the ACLU. Whatever you think about them, they don't have a commercial interest in this case. So to me, Judge Sweet did what he did because that's what he was asked to decide. And that's not covered by the case law in the very direct way that it was served up to him by the ACLU.
I see. And next, why do you think that the Myriad process patents have a good chance of remaining invalid on appeal? Is that based on what you think the Supreme Court is likely to rule in Bilski?
Yes, this is a house of cards, a pyramid of guesses. Yeah, I would be really surprised if the Supreme Court was not at least as restrictive on process patents as the Federal Circuit was in Bilski. So my bet, again a quarter, on the Supreme Court would be they're going to tighten the test up even more. If that happens, Myriad-style patents, Prometheus-style patents could be in more trouble. And that would be a far less radical holding than what Judge Sweet has done on the product of nature gene patent side. So to me, that's a more likely outcome than final invalidation of the gene patents themselves.
Okay. We're getting a lot of nuts and bolts questions, excellent ones, regarding the legal and practical effects of the Myriad decision. So if you could illuminate us a little bit on who is bound by this. We understand that other district courts are not bound by it, but under the issue of the principle of issue preclusion, are other plaintiffs going to be able to take advantage of the Myriad decision in other venues outside of the Southern District of New York? One of the questions along these lines is that Myriad says that they have many patents, about 23, and many claims, i.e. 179, relating to BRCA1 and 2 testing. If Judge Sweet is upheld on appeal, how many how many of these other claims would fall as well. Actually, before you get to what happens on appeal, let's break it apart. What's the state of the law today? What's the effect of this case until we get to an appeal?
This case does not change the state of the law in that it's a federal trial court, the Southern District of New York, and it doesn't bind any other court. So that's the first principle. A district court down here in Raleigh could reach exactly the opposite conclusion this afternoon. Now, I don't know of any other case just like this that's pending, but if there were another case, another district court could come out 180 degrees opposite. So in terms of the state of the law, no other federal court is bound. The Patent Office is bound on these patents in a way that I'll get to in a moment, but this I don't think will be seen by the Patent Office now, today, as a directive to change their examination guidelines or their standards for granting patents. It's just a district court opinion. Now, when the Federal Circuit rules, different ballgame. All federal courts hearing patent cases would be bound, not the Supreme Court, but all federal district courts hearing patent cases would be bound by whatever the Federal Circuit says, and the Patent Office would have to immediately change their examination guidelines and standards if the Federal Circuit were to come close to upholding this decision. So it's important to emphasize that what this doesn't cover. Okay, what about the decision itself and its effect on Myriad and others? The decision also does not affect any of all these other Myriad patents. It doesn't affect, excuse me, directly any of all the other Myriad patents that weren't before the court. Now, in order to come up with an opinion as to if this case stands, what's going to happen to the other Myriad patents, you got to go and read the claims. You have to go patent by patent, claim by claim, and say this decision does or does not affect this particular claim. But I know Myriad has been out there saying we got lots of other patents. They've been saying that to investors, and that's true. But
that's exactly one of our questions that's just come in.
Okay.
What about the claims that weren't directly attacked by Myriad?
The claims that weren't directly attacked are not legally affected. Okay, let's talk for a moment about the claims that are and what happens here. I just pulled out the last page of the opinion, and it says, this is the last clause in the opinion, the claims in suit, that is, all the ones that are named in the opinion, are declared invalid. And then it says, submit judgment on notice. So the court is waiting for a draft form of final judgment to be submitted by the prevailing parties, and then it will issue its own directive. But the claims in suit are declared invalid. So as of the moment that this was signed, those claims are invalid. So 5 minutes after this was signed on the 29th, Myriad was not in a position to enforce these claims on other people. Now, it is possible, probably likely, that as this case goes up on appeal, this judgment will be stayed or suspended. So the world, possibly, the world, even Myriad's world, will continue unaffected pending the appeal. Not necessarily, but that's a possibility. But as of now, these claims are invalid. I said it's not binding on any other district court. But if Myriad took these claims and sued some other alleged infringer in Raleigh, North Carolina, let's say, unless and until this is reversed on appeal, Myriad would lose because of an arcane procedural doctrine called issue preclusion. Nobody who's still awake out there wants to hear about that, but there are very technical procedural reasons why Myriad would lose if it tried to enforce these very same claims on other infringers during the pendency of the appeal.
Which actually gets right to the bottom line of one of the questions that came in. Is it your understanding that other labs around the country can now legally offer BRCA testing? Putting you on the spot.
Yeah, depending on whether this judgment is stayed. If this judgment is not stayed pending appeal, I would tell a lab that you have a window, unless and until this is reversed on appeal, when you could use these patented genes. Now, by the way, that's not a legal opinion. Don't act on it, especially don't sue me if it's wrong. That's just a public speaker academic opinion. But yeah, that would be the effect. Now, given that the appellate process, while long, is probably not going to be longer than a year, are people going to go out and invest money on their ability to use the myriad genes? I wouldn't put my money there, because we got to wait for the Federal Circuit.
Yeah.
I wouldn't think anything in the economic world, outside of the boundaries, I wouldn't think anything in the economic world, the business world, ought reasonably to change until we hear from the Federal Circuit.
Okay.
I don't think investors are likely to behave differently. They're crazy if they do. And I don't think people doing science ought to be plunking down money today in reliance on this opinion.
Okay. Can you explain what happened to the Patent and Trade Office in this decision? Are they out of the case?
No.
They're still in?
No, they're still in. The one thing the judge didn't do is deal with the constitutional claims. And he did it just under a rule of judging in the federal system that says if you have an adequate statutory grounds to decide a case, don't mess with the Constitution unless you don't have to. And that's what he said. He said, here's what I want to do. I'm going to do it under the statute, so I'm going to leave the Constitution alone. But
don't waste my breath. I've already written
held
150
earlier,
pages.
you can keep the Patent and Trademark Office in.
Yeah, okay. Now, moving on to the appeals court, what can the appeals court do? What can it not do? What are its options?
On a case like this, it can do pretty much whatever it wants. I think what will happen here is that Myriad will appeal the grant of this summary judgment, the denial of its summary judgment, and the record of the case. Appellate courts act on records. They don't conduct new trials. They act on written records. In the record here, you got cross motions, both directions, for summary judgment. You got this opinion. The appeals court, among its options, would be affirmed, which means this judgment stands. It could say affirmed on one set of claims, reversed on the other set, the two sets being the genes and the processes. So it could mix and match in that way. If on any or all of the claims it reverses, if it throws out this opinion, it then wouldn't be in a position to say, this really isn't a summary judgment case. The facts are disputed, so go back and conduct a trial. Go back and do this all with a trial. It could also say, we disagree with what Judge Sweet did, but it really is a summary judgment case, so we're going to institute effectively our own summary judgment. So it could do anything from ordering a new trial to issuing a judgment like this one or different from this one. So everything's on the, given the way this case is structured, everything is on the table for the Court of Appeals.
One last bit of prognostication. What do you think about the Supreme Court's likely views on this matter?
Wow. The Supreme Court obviously has a lot more leeway to act on policy than do all other courts in the federal system, including the Federal Circuit. I think the Supreme Court, if it got this case, would be very concerned about the process claims. I think the process claims would be in big trouble in the Supreme Court. As interested as the Supreme Court has been in whether biotech patents have gone too far, I would nonetheless be shocked if they threw out the gene patents themselves. more likely there, I think, than in the Federal Circuit. But that would still shock me. And the reason would be the economic edifice that has been built on the patentability of genes. So that would be my guess, that if it got to the Supreme Court, the process patents would not survive. The gene products claims probably would, but who knows?
Yeah. One comment from...
if we knew, we wouldn't need law professors.
That's right. One comment from a listener is that she would suggest that anyone thinking of doing BRCA 1 and 2 tests really take a close look at the claims in the patent in the lawsuit that were not attacked and are therefore valid, and encourage people to be cautious because some of the claims that were found, some of the claims that may affect BRCA 1 and 2 testing were not attacked and remain valid and could be infringed.
Yes,
So caution may be in order.
Yeah, and just she's absolutely right. And just to underscore that, the only way to gain confidence about whether other patents cover what you're doing is to have a patent lawyer read the claims and understand what you're doing and say they do or don't. There's no shortcut. I don't mean to be doing a commercial for patent lawyers, but there's just no shortcut there.
We still have a number of wonderful questions, and I'm going to urge people to send them to you. But one last one that we'll deal with since we've gone over is a procedural question. If the appellate court does decide that a trial is necessary, would it go back to the same judge?
Yes.
Okay. And then,
I mean, yeah, it would be extraordinary, I think, on these facts to go to a new judge just because this one had been reversed. I mean, this judge obviously has some strong views on the legal merits, but judges are supposed to know how to take their medicine, and if they're told they're wrong on the law, apply the right law. There's nothing, I've heard some comments about Judge Sweet's hostility to this and that, but that strikes me as a bit paranoid. I mean, this is a scholarly, professional opinion, and you may or may not like it, but yeah, I would think we'd go back to him.
Okay. We've got great questions, and please keep the dialogue coming. Thank you very much, and good afternoon.